My name is Mark Rawson, and I'm an attorney who works with entrepreneurs and startups. Today I'll be talking with you about the legal risks of crowdfunding. Primarily in connection with reward-based crowdfunding, which is the kind most people are familiar with, where donors make cash contributions in exchange for a reward. The most popular platforms include Kickstarter and Indiegogo. First, I want to warn you about losing your intellectual property rights. Crowdfunding platforms will not protect your intellectual property rights. It's your job to do so. Therefore, when you publicly disclose your intellectual property on a crowdfunding platform, it can have an impact on its legal status. You should be aware that there are sophisticated IP predators who will go on these crowdfunding platforms and look for unprotected ideas that they can exploit. Before you launch a crowdfunding campaign on Kickstarter or another reward-based crowdfunding platform, you need to take steps to protect your company's intellectual property. First, when it comes to patent rights, you should be aware that when you disclose your idea on a crowdfunding platform and you've disclosed it to the public or offered your item for sale, the U.S. patent application must be filed within 12 months. The crowdfunding process can start this 12-month clock. The United States has recently adopted a first-to-file system for patents. This means that anybody can patent an idea without having to prove that they were the first to invent. Therefore, if you launch a crowdfunding campaign before you file your patent application, you could find yourself in a race with donors to be the first to file at the patent office. There is a way around this, however, and it's called a provisional patent. The problem is many businesses don't have the funds to file a formal patent application, which is a very expensive process. The solution provided by the patent office is to allow what's called a provisional patent. It's an informal patent application. The cost is much less than a formal patent application, and it takes less time to prepare and file it. However, you need to be aware that the provisional patent must be replaced by a formal patent application within 1 year. So this basically buys you a year in which you can launch your crowdfunding campaign and see if you meet your project goals. And if you do, then you can file an actual patent application. And if you don't reach the goals and you find out that your idea is not viable in the marketplace, well, now you've saved yourself quite a bit of money in legal fees, since you didn't need to file an actual patent application just to hold your place in line. When it comes to foreign patent rights, you should be aware that when you put your idea up on a crowdfunding platform, you're exposing your idea to a global audience over the internet. Therefore, if you intend to sell your product worldwide, you should file for patent protection in the countries where you intend to market and sell your product. Otherwise, you could find out that there are knockoffs of your idea in foreign markets before you even launch. Therefore, you should research the patent rules in every country where you intend to offer your products for sale and consult with a patent attorney who is knowledgeable about international patents. Another area of concern for entrepreneurs who use crowdfunding is losing control of their idea. When you use a traditional investment model where you meet face-to-face with your investors, the entrepreneur can use non-disclosure agreements and non-compete agreements to protect their ideas. But when you put your ideas up on a crowdfunding platform, they're simply not set up for this type of protection. Another area of concern has to do with using suggestions that have been submitted by users of your crowdfunding platform. There are sites that will allow users to post ideas and suggestions, and some sites will specify that the project sponsor owns the rights to those comments. However, there are some sites that do not define ownership of the submitted material. The problem here is that when you incorporate the ideas from these donors, you could end up having some legal obligation to the person who submitted those ideas or suggestions, and you want to make sure that you check the terms of your crowdfunding platform before incorporating any of those ideas into your business, or consult with an attorney who's knowledgeable in this area. In terms of losing your brand, you certainly want to be aware of any risks that are posed to your trademark rights. In the United States, the system is a first-to-use system, and therefore whoever uses the trademark in commerce first can claim a right to that mark, whether or not they've registered it. So, for instance, you could sell your product with your trademark on it, and this counts as being the first to use it in commerce. What is not clear is whether simply using this trademark in a crowdfunding campaign on a crowdfunding platform is considered use of the trademark. If that's the only use you've done with your trademark and you've not actually put it on your goods and sold them in the marketplace, the trademark office may not consider that to be a use of the mark. And the problem is, if you publish a crowdfunding proposal where you include the name of your product or business, and another party actually sells that product with the same name on it, the other party could be considered the first to use the trademark in commerce, and they, not you, can claim the trademark rights. One possible solution for an entrepreneur who plans to use an unregistered trademark in their crowdfunding proposal would be to file what's called an intent to use trademark application before publishing their crowdfunding proposal, and this will hold your place in line until you can actually use the mark in commerce and file an actual use trademark application. Another solution would be to simply avoid using the unregistered trademark in your crowdfunding campaign and not put a brand name on the product that you're describing until after you've actually sold some units in commerce. Another risk in losing your brand name is losing the domain name that goes with your brand. This can happen if you reveal your product or brand name before you've registered the domain names. Somebody else could register that domain name, and then it would be very expensive to try to get it back from that person. The solution would be to simply register all of your relevant domain names before you launch your campaign, especially any .com domain names that you hope to have now or in the future. You may be aware that there are anti-cybersquatting laws which can help you get your name back through legal action. However, there is a risk that you might not be able to meet the burden of proof required to make use of this law. For instance, you need to prove that you registered your trademark prior to the alleged cybersquatting. If you did not have a registered mark, then you will have a difficult time proving that the cybersquatting took place after you had ownership rights to the mark. Also, you need to prove that the domain name was registered in bad faith, and this can be a difficult burden of proof to meet. Therefore, it's best to simply register the domain names that you need prior to revealing your trademark to the public. Another risk for entrepreneurs is that when they post their campaign on a crowdfunding platform, they could find out that they're infringing on someone else's copyrights, trademarks, or patent rights. And once you have posted your campaign on a crowdfunding platform, you might be alerting others of this potential infringement. Therefore, you want to have an attorney review your brand, your technology, and your crowdfunding content before you launch your crowdfunding campaign to make sure that you're not infringing on someone's existing rights. Also, be sure that when you post anything as part of your crowdfunding campaign, that you have the right to use the photos, the images, and the words that you're using in your campaign. Make sure that if you have used a professional photographer, or if you're using stock photography, make sure that you have the proper permission forms or the proper rights secured to the images that you're posting. And also make sure that if there's a model that you've used in your photos, that you have a release form signed by that person. Even if it's a friend or family member, still have them sign a release form that gives you permission to use their likeness in your campaign. Another risk is that you could get sued for fraud, and this can happen if you've misrepresented your project or your product to the public. So avoid misrepresentations, make sure you don't promise what you cannot deliver, make sure you disclose potential risks or problems that might impact on your ability to deliver. And remember that even an innocent misrepresentation can look like fraud in hindsight, so you want to make sure that you review your project very carefully before you launch your campaign, and that you make sure that you're not overpromising. And finally, you want to make sure that when you set up your crowdfunding campaign, that you don't post your campaign as an individual, because this can impose liability on you as an individual. Instead, what you want to do is establish a separate legal entity for your Kickstarter campaign to avoid being held personally liable. If you don't already have either a limited liability company or a corporation, you should set one up or talk to an attorney about setting up a separate entity that will be accountable for any liability should there be a problem with your crowdfunding campaign. If you need more information about any of the topics I've discussed, check out my website at rawsonlaw.com. I've got a lot more information up there that will be very helpful in setting up your crowdfunding campaign, or feel free to reach out to me through my website. I'd be happy to answer any questions that you have, and good luck.